Hello there. Today I will be discussing the investigatory powers of Congress, specifically two cases and a comparison of the two. Before we can get there, though, we have to understand where the investigatory powers of Congress come from. These powers are an implied power, meaning they do not come from the Section 8 of Article 10 that specifically says what Congress can do. They do arise, however, from the 18th clause of that section, which is the necessary and proper clause. This clause states that Congress shall have the authority to make any laws they deem necessary and proper to promote and support the powers enumerated within the Constitution. Two views you can use to look at this and that have been used in history are the strict constructionist or anti-federalist, also called Hamiltonian view, which states that Congress can only pass legislation it views as necessary and proper to support the powers enumerated to it. Another view held in history is the federalist or loose constructionist view, stating that Congress can pretty much pass legislation towards anything it deems necessary and proper. The final authority on this extent of Congress's power lies with the Supreme Court. However, this is not an easy job, as necessary is a very broad term with wide interpretation. While the investigatory powers of Congress are non-enumerated, they are, however, non-controversial, with the ability to pass legislation necessitating the need to gather information. Constitutional questions do arise, however, when looking at the permissible scope of congressional inquiries, as well as the punishment for non-compliance. In the 1881 case of Kilbourne v. Thompson, the majority opinion spelled out the permissible scope of such investigations, that Congress could not, through investigation, infringe on powers held by the other two branches of government, that anything Congress wanted to investigate must be something that it can legislate, and any pursuant investigatory powers of Congress must be at issues leading to possible legislation. One other thing underscored by this case was that personal affairs could not be investigated without leading to an overriding legislative interest. In 1927, McGrain v. Doherty upheld these provisions, as well as stating that a witness called before a congressional inquiry could refuse to answer questions so long as those questions exceeded the scope of Congress's authority in the matter. This was what was at issue with the case of Watkins v. United States, which we will be discussing in further length. Changing time periods from 1927 until the mid-50s, when these cases arose, was during the World War II and post-war era, where congressional inquiries were focused primarily with communist ideology being pervasive within the United States borders. Many will be familiar with McCarthyism and the Senate and House investigations into, quote, un-American activities. During this time, Congress held a surprising number of people in contempt for either refusing to answer questions or refusing to testify before investigatory committees. One of these people was John Watkins, who, when being investigated by the House Un-American Activities Committee, refused to answer a question about former members of the Communist Party of the United States. While Watkins agreed to answer any question involving his own activities or the activities of current members, Watkins refused to testify on members who had since left the Communist Party. After being held in contempt, Watkins appealed his contempt charge, and the resulting case hinged on whether or not the House committee had erred in exceeding its scope. The justices, in a 6-1 decision, two justices sat this one out, decided that while the committee's justification and charter were surprisingly vague, that Watkins had the right to not answer these questions for the sole reason that he was not given enough information to decide whether or not to answer the questions. The ruling doesn't really decide on whether or not this justification for the committee was something that was constitutionally viable. The issue before the court was one of pertinency, and more specifically, whether whether their questions were pertinent to the investigation before them. Watkins alleged that the questions being asked were not pertinent, whether or not these questions had anything to do with the charter or justification for the committee. And when the committee gave him a response that the court found not sufficient in answering this question, that was the issue that the court decided the committee had erred. The justices are surprisingly silent on whether or not the committee's question was pertinent. It was more the matter of whether Watkins' due process rights were violated when he was not given enough information. In saying that, I would argue that a legal model of judicial decision-making is most apt in understanding this court ruling. The court chose to follow the guidelines laid down in both Kilbourne that we've discussed as well as Doherty, and really didn't overturn anything, with the votes falling on both sides of the ideological spectrum possessed by the judges. I can't argue it's an attitudinal model. The justices looked back to whether or not a question before a witness was allowed to be asked, and used the ideas of the witness's due process rights in deciding that question. Later on, though, 2 years down the road, in the next case we will be covering, the justices were once again called to answer a question of witnesses' rights in committee investigations. In the case of Barenblatt v. United States, once again the House Un-American Activities Committee was investigating somebody for un-American activities. This time it was a university professor, Lloyd Barenblatt. During his investigation, or while testifying before the committee, Barenblatt refused to answer questions regarding his affiliation with the Communist Party as well as questions regarding other members. When the case reached the Supreme Court, the Barenblatt and the ACLU representing him rose a First Amendment question of whether Barenblatt had to announce his affiliation with the Communist Party under the First Amendment protection of freedom of association and expression. The court did not respond well to this line of reasoning, however, and basically said that the necessity of the government outweighed the First Amendment protections in this matter, that the First Amendment does not protect an individual from all lines of questioning. While issues brought up in Watkins were raised, primarily the, once again, broad nature of the House Un-American Activities Committee and their charter, these were dismissed quickly, with the justices trying to separate this case as much as possible from Watkins. And in looking at it, one can see that while Watkins only wished to respond to questions he saw within the scope of a congressional inquiry, this time Barenblatt was refusing to answer questions about his own involvement. Scholars are divided as to which decision-making model can best be used to understand the decision in Barenblatt. Some will point to the attitudinal model. In the years between Watkins and Barenblatt, two new justices were appointed to the bench. And with this new ideological makeup, it would explain how in Watkins, the court sided with an individual over the congressional inquiry, and 2 years later, in Barenblatt, decided with the congressional inquiry over the individual. Others will point to the strategic model in that the justices were starting to feel pressure from both the federal government as well as the American public for standing in the way of the House and Senate committees. I would instead argue that this can still be seen in a legal model. When viewing the two cases side by side, Watkins was willing to answer questions about his own activities and only question the committee's ability to ask questions about previous members. In Barenblatt, Barenblatt refused to answer questions on his own activities. And so we see that these cases were looking at two different aspects, as argued by the justices in the second case.